let's take a look at privacy in administrative law and public administration. The Federal Privacy Act of 1974 reflects the APA's broad interest in protecting individual rights against administrative encroachment. Its coverage within the executive branch is similar to FOIA, though somewhat broader because it extends to advisory units in the executive office of the president. The Privacy Act is primarily concerned with regulating the collection, management, and release of information regarding individual citizens and permanent residents. The following are its main features: access to records. Individuals have the right to review agency records on them. If they find errors, they may request that the records be amended. If the agency refuses, the individual involved may file a statement of disagreement, which essentially becomes part of the record. Management of records. Agencies are required to publish notices in the Federal Register explaining the nature of their record systems and policies regarding access, disposal, storage, and related matters. They must also develop safeguards against inaccuracies and misuse of information, including through computer matching. Restrictions on disclosure. In principle, the Act prohibits the disclosure of any record on an individual without his or her prior consent. However, there are 12 specific exceptions in which such consent is not required. The Privacy Act is enforced through civil lawsuits and criminal prosecutions, though instances of the latter are very rare. The Privacy Act is not produced a great deal of litigation, perhaps because its exceptions are broad and winning damages is difficult. Every state has a counterpart of the federal act. Privacy may be further protected by regulations requiring agencies to develop privacy impact assessments dealing with personal information held in electronic form and shared among agencies and levels of government, such as contained in the implementing recommendations of the 9/11 Commission Act of 2007.